Good evening. I'm Christine Farley, a professor here, as well as one of the faculty co-directors of our program on information justice and intellectual property law. We call PIJIP. Some people here today have called PIJIP, so whatever you like. And it is my pleasure to welcome you to the 12th annual Peter A. Jaszi Distinguished Lecture in Intellectual Property. I'm so glad to see so many of my colleagues and my students and alumni and friends and others. And I am very gratified to know that we have an additional at least 200 people who are watching us online from all over the world. And sorry to those of you online, but I have to make this introduction so that I don't forget. There's going to be a really nice reception after the lecture. And it's going to be not here. You're going to have to travel down the hallway. So get down this hallway until you see a very nice, large painting created by a human being. And you're going to take a left and go to Grossman Hall. Also, before we begin, I would like to acknowledge that the university is built on the traditional lands of the Nacotchtank people. So 12 years ago, we redesignated our annual IP lecture series in honor of our dear colleague, Peter Jaszi, who it is my honor to introduce to you now. I believe 12 years ago, I observed that Peter was the only person in the room who needed no introduction. But sadly today, because of Peter's retirement, we now have students and alumni who haven't had the pleasure of being in Peter's class, and that is a travesty. So I'd like to tell you a little bit about him. Peter taught at this law school for 40 years, and he holds the distinction, as far as I know, of being the only person who has taught every first-year class, even crim. Okay, not crim, except for crim. Peter, of course, was the founder of our PIJIP program, as well as being the founder of our IP clinic, the Glushko-Samuelson IP clinic, which along with Berkeley was the first clinic in the nation to address IP. He has written many books, book chapters, and articles on copyright, IP, technology, and other topics. And I'll just mention one: Toward a Theory of Copyright, The Metamorphosis of Authorship, in the Duke Law Journal, 1991. I mention it because I read it while I was a law student, and it convinced me that I should pursue IP. Peter has had and continues to have the fullest possible career as a public intellectual and a public interest advocate. And here's just a sampling of his activities. He's testified numerous times before Congress on copyright matters. He served as a member of the Librarian of Congress's Committee on Copyright Registration and Deposit. He served as a trustee of the Copyright Society and currently sits on the editorial board of its journal. He was the principal founder of the Digital Future Coalition, providing powerful copyright advocacy during a pivotal period of time in the 1990s. For almost 2 decades now, he's been working with AU professor Pat Aufderheide, who's here with us today, to help creative communities develop fair use guidance documents that reflect their particular problems and practices. He was part of the legal team representing the National Federation of the Blind in the Authors Guild versus Hathi Trust litigation. And you may not know this, he has an IMDb page listing 40 film credits for his fair use legal advice. He's also received numerous awards, including from this university, and including the Ray Patterson Copyright Award from the American Library Association, the Champion of Intellectual Property, which I think is a title that he may not like, from the IP section of the DC Bar, and the IP3 Award from Public Knowledge. And this is a heavily curated list of that really fails to capture the impact that Peter has had on the field and on all of us who have seen him in action. So this annual lecture series serves as both an invitation to the uninitiated, and for those of us who've had the chance to bask in Peter's brilliance, it serves as a celebration of our good fortune. So now let me welcome to the podium, Peter Jaszi.
Express my appreciation to you for having turned out for what I think is going to be a wonderful lecture. Here are some essential things to know about Matt Sag, if you don't already. One is that at Emory Law School, where he has taught since 2022, he has the best official job title of any law professor I know. He is formally and officially Professor of Law and Artificial Intelligence, Machine Learning, and Data Science. That is something. And I know now what I should have. I mean, I should have bargained in my earlier years for a more extensive and descriptive title. I didn't have the imagination to do so, but it's very impressive. Matt was born and educated in Australia, earning law honors at the Australian National University in Canberra, and then clerking for Justice Paul Finn of the Australian Federal Court. Now the story gets interesting. He went on then to work in London for Arnold and Porter. And at age 26, he came to the United States practicing in Silicon Valley before entering academia. Now, this is a sequence of events that leaves me with a special regard for the even-handed liberality of the state of California's bar admission process. The fact that this distinguished young foreign lawyer could qualify in California and then go on from there, it's a wonderful thing. It's a thing we really ought to treasure and value that California has given us. In the years since, Matt has published even more full-length traditional law review articles than he has run full marathons, which, it's an impressive total either way, but taken together, formidable. I've loved his work since I first read it in the early years of the millennium. The two articles that I read first were the Prehistory of Fair Use and Predicting Fair Use. I wonder why I went for those right away, but they're wonderful pieces, and I knew immediately that this was a special talent and someone to watch. They're pieces that demonstrated, even at that time, his mastery of a range of methodologies, along with a clean prose style, which is not easy to accomplish when talking about topics of the kind we're engaged in, and a very, very attractive dry sense of humor. So I went back then, devoured his early writings on, among other things, copyright and technology. And when I say among other things, a lot of other topics were covered as well. And then over the years that followed, I've watched with growing admiration as his diverse scholarly communications have showcased his skills as a tough empiricist with a gift for pattern recognition, while at the same time addressing what seems like an ever-widening range of topics, including copyright trolling, injunctive relief in IP cases, and of course, internet safe harbors. I'd also be remiss not to mention a remarkable series of articles, which I really commend to you, which Matt has written along with his wife, Tanya Jacoby, who is here tonight, about attitudes, the rigorous study of attitudes and behavior on the bench, at the bench of the United States Supreme Court. These are just remarkable pieces, incredibly enlightening. I certainly would recommend them to anyone who is going to engage in Supreme Court practice from this point on, because there's a lot to learn. But simply as methodological exercises, they are so satisfying and in themselves So I recommend it all. Those are really special pieces. I don't want to stop here because although I can't really summarize the next point I want to make as effectively as I can, Matt's career of formal scholarship, I do want to acknowledge that he's more than a preeminent copyright scholar. He is obviously a beloved teacher, and he is, and I don't have quite the right word for it, but the one that I would tend to use, I think, is he's an outstanding copyright citizen. He's a champion of access to information who engages with current issues that really matter through informal writings, through extraordinary friend of the court briefs, through congressional testimony, among other means. And these interventions have helped to make him a trusted source of policy guidance on a range of issues, including text and data mining, and now, of course, the regulation of artificial intelligence, about which he will speak this evening, and we will all, or many of us, I hope, continue to talk tomorrow. In concluding, I'd be remiss not to mention that Matt is a connoisseur of science fiction in all media and a self-identified proud dyslexic, a term on which he expands eloquently in a post on his personal website, which is definitely worth a visit. Most of all, though, Matt is a dear friend of PIJIP and of all of us who call PIJIP our intellectual home. Thank you very, very much for coming this evening, Matt.
Well, after that introduction, it's hard to know how to compete, but I will do my very best. So this is a talk in 5 parts. Peter Jaszi is well known for his deep philosophical and historically informed meditations on copyright law and the nature of authorship. He's also well known to most of us here for his humility and generosity. These characteristics manifest in one of Peter's most important contributions to American law and culture, the fair use best practices. Over the past 18 years, Peter and his collaborators have brought together communities of practice ranging from documentary filmmakers to software archivists to express their understandings of what fairness requires. What emerges from the fair use best practices, considered as a whole, is that fair use is not a matter of taking from one group and giving to another in the name of efficiency or distributive justice. Fair use is a mechanism for recognizing potential conflicts in legitimate interests and navigating between them in good faith. Facilitating this process requires a deep knowledge of copyright law, a gift for storytelling, and a willingness to listen to others. In a nutshell, it requires being a lot like Peter. And so you can see why it's such a profound honor to be presenting here today the 12th annual Peter A. Jaszi Copyright Lecture. Although we are still a long way from the science fiction version of artificial general intelligence that thinks, feels, and refuses to open the pod bay doors, recent advances in machine learning and AI have captured the public's imagination and lawmakers' interest. We now have large language models, or LLMs, that can pass the bar exam, carry on what passes for a conversation on almost any topic, create new music and new visual art. These artifacts are often indistinguishable from their human-authored counterparts. This was illustrated in September last year when Jason Allen's painting won first place at the Colorado State Fair. And as reported by the Washington Post, the portrait of 3 figures dressed in flowing robes, staring out into a bright beyond, was so finely detailed that the judges couldn't tell. Generative AI systems like GPT and Llama, the language models of Stable Diffusion and Midjourney, the text-to-image models, were built by ingesting massive quantities of text and images from the internet. This was done with little or no regard to whether those works were subject to copyright or whether the authors of those works might object. The rise of generative AI poses important questions for copyright law. These questions are not entirely new. Generative AI gives us yet another context to consider copyright's most fundamental question. Where do the rights of the copyright owner end and the freedom to use copyrighted works begin? Some jurisdictions will choose to answer this question with special rules relating to generative AI. Others will rely on the application of fair use or perhaps even fair dealing. Still others will hide their heads in the sand and be left behind as this technology develops, or simply tacitly allow widespread infringement. My aim here tonight is not to convince you that generative AI is or should be non-infringing. It's to outline an analytical framework for making that assessment in particular cases. Today's generative AI models are machine learning models trained on social media posts, books, articles, photos, digital art, music, software, and more. Rather than simply classifying these diverse inputs and generating metadata about them, as previous generations of machine learning systems have done, generative AI models can produce new digital artifacts. That's new text, new music, new art. The software industry is prone to hype and speculation, so we should be skeptical about claims of AI exhibiting sparks of general intelligence, to quote one paper. We should understand that just because a chatbot can pass the bar exam doesn't mean that it has acquired the knowledge and the skills that the bar exam is meant to test for. But even setting aside hype and speculation and overly credulous reporting, of which there is a great deal, I have no doubt that generative AI is a transformative technology. Generative AI will make office workers, authors, artists, and musicians more productive. It will open up new possibilities for people who lack specific artistic and musical competencies, enabling them to nonetheless create new art and new music. Generative AI will allow disabled artists to create new works, overcoming physical limitations. And like photography and mechanical music did decades ago, it will challenge existing notions of what makes human-generated works interesting or worthwhile. Generative AI will enable individuals and companies to do more with less. Whether that implies an increase in creative production or a decrease in employment is a very difficult question to answer in the abstract. Certainly, not all increased productivity is beneficial. Generative AI will also enable bad actors to do more with less. It will accelerate internet scams, disinformation, and propaganda, and it will flood the internet with useless clickbait and banal search engine optimization. Ultimately, as a surprising number of serious people seem to think, today's generative AI technologies may be a step on the path towards systems with agency, a capacity for real-world action, and human-level intelligence, or even superhuman intelligence. Such systems might exhibit power-seeking behavior and pursue misaligned objectives to the detriment or even ultimate extinction of humanity. Copyright law is far from the ideal instrument to balance all of the potential harms and benefits of artificial intelligence. But copyright law has a lot to say about copying, and there is a great deal of copying involved in almost every machine learning application. The first stage in developing a machine learning model, once you know what you want the model to do and how you want it to do it, is identifying and obtaining access to the relevant training data. The more data, the better. There are many different types of generative AI, and it's possible that some were trained by exposure to the training data without a locally stored copy. But this is quite uncommon. Typically, all the companies you've heard of, OpenAI, Google, Stable Diffusion, they're training their models on locally stored content for sound technical reasons. But there's no doubt that this is an act of copying under Section 106(1) of the Copyright Act. As I will describe in more detail a bit later, this process of gathering and pre-processing the training data is the first set of copyright relevant activities in the process of building a machine learning model. And most of the time, it's also the last. Once the training data has been gathered and pre-processed, the process of training a language model like GPT-4 or an image model like Stable Diffusion should not create additional copies of the training data or any kind of derivative work based on the training data. Despite this, the fact that the training is almost inevitably preceded by massive copying is enough to create colorable claims of copyright infringement. Additionally, there are some exceptions to the description I've offered already. Sometimes machine learning models do in fact copy the training data and produce objects that are arguably similar in output. For both these reasons, recent lawsuits alleging copyright infringement by generative AI must be taken seriously. There are some key differences between these suits, and they raise many causes of action in addition to copyright. But each one of them argues or implies that fair use is an insufficient justification for the massive amount of unauthorized copying required to assemble the training data for generative AI. Accordingly, the question I want to frame here tonight is, how should we think about fair use in this context? The fair use doctrine carries a lot of weight. The fair use doctrine began as a gloss on the statute, a way of understanding when one work borrowed too much or contributed too little on top of earlier works. But over time, and accelerating dramatically with the internet age, fair use has been asked to do more and more. Today, fair use is not just copyright policy, it's cultural policy, it's freedom of expression policy, it's technology policy, it's platform regulation, and now it's the key to determining how artificial intelligence will develop. The question is whether fair use can carry this weight. 33 years ago, Judge Pierre Laval urged courts to make transformative use the predominant factor in their consideration of fair use and resist the impulse to import extraneous policies into that analysis. Laval was prescient. The copyright questions relating to generative AI illustrate why now, more than ever, we need a fair use doctrine that is guided by fundamental principles derived from copyright law itself and not, or at least not primarily, broader conceptions of the public interest. Laval's great insight was that rather seeing fair use as a tax or a subsidy or an ad hoc balancing tool, courts should understand fair use as an integral part of the copyright system, as a reflection of copyright law itself. Laval emphasized the importance of transformative uses that employ some amount of the author's original expression for a fundamentally different purpose, or give that expression a manifestly different character. Laval's argument, adopted by the Supreme Court in Campbell versus Acuff Rose, was that a copyright law that did not allow transformative uses would inhibit reference to and reinterpretation of existing works and thus contradict the ultimate utilitarian purpose for copyright. In other words, the purpose of copyright and the purpose of fair use were one and the same: to promote the creation and dissemination of new works of authorship. It's possible, however, to take Laval's purposive reading of fair use too far. The reaction of some of my fellow copyright academics to the Supreme Court's recent decision in Andy Warhol Foundation versus Goldsmith reflects a widespread, if somewhat inchoate view that the role of the fair use doctrine is to allow good things to happen. On this view, the Andy Warhol version of Goldsmith's photo of Prince was a good thing and thus should have been allowed. Certainly, this is Justice Kagan's view in dissent. The same sentiment is expressed with more precision by those who frame the role of fair use adjudication in terms of a cost-benefit analysis, wherein the court is supposed to balance the social value of lost authorial incentives against the value of allowing the use to continue. On this view, fair use is a public policy instrument, pure and simple, a way of fine-tuning copyright rewards for the greater good. Take a moment to consider a US federal judge or a jury and how they would approach the fair use questions behind generative AI under such a cost-benefit analysis. What would this broad public policy evaluation look like? A court engaged in this process might start by considering the ways in which the process of extracting patterns from copyrighted works and constituting new works derived from those patterns was transformative, i.e., the extent to which it added something new and gave the existing text new meaning and message, words that we're all familiar with, I'm sure. But then it would have to consider, and I have a long list, I'm sorry, the prospect that generative AI could be used to generate and propagate misinformation, deepfakes, hate speech, cyber attacks, and phishing emails. The use of generative AI might lead to the disclosure of private information, that AI models of all sorts have been shown to perpetuate and exacerbate the biases in their training data, that the ubiquity of generative AI might lead to ever greater cultural homogenization and conformity, that generative AI might become so useful that it created an unhealthy dependence on technology, that the use of generative AI might lead to significant unemployment in the very same cultural sectors that provided the initial training data. And let's not forget that an AI trained on copyrighted works might progress to the point where it becomes deceptive and power-seeking, surpasses human intelligence, and poses a substantial risk to humanity. On the other hand, the court would also have to consider that generative AI might promote the public interest. It's going to make a lot of people more productive. It's going to enable a lot of new creativity. It's going to reduce the cost of education and training in all sorts of ways. And it's going to accelerate scientific research. And as we've already seen, it's going to make new forms of scientific research possible. In theory, a purely cost-benefit approach to determining fair use would end up with the entire question turning on whether a judge believed that the supposed existential risk from AI was a 1% likelihood, in which case it definitely should not be fair use, or a 0.0000001% likelihood, in which case maybe it's a close call. A permissive fair use ruling, in other words, it might unshackle the next generation of socially productive technology, or it might bring about Skynet and the singularity. Perhaps this talk of existential risk is a bit too far-fetched. But we see the same problem in miniature when some argue that the use of copyrighted works as training data for machine learning should be allowed because it leads to more balanced and representative data and thus reduces biases. And yet others contend that training facial recognition software on copyrighted works should not be fair use because space surveillance is misused by the police and harms marginalized communities. Should the fair use status of machine learning really depend on such policy judgments? Should a court find that scraping wildlife photos off Instagram to train an algorithm to detect zebras for conservation purposes is fair use, but undertaking exactly the same process for detecting and identifying human faces is not? Suggesting that copyright should not be directly responsive to these broader public interest arguments is not my way of saying these things don't matter. There is some space for value pluralism in copyright adjudication, but fair use and copyright law in general should turn on coherent legal principles, not abstract policy judgments. Law reviews are full of praise for the notion that copyright law should strive for balance to achieve its ultimate objectives. And it's hard to disagree. But the nature of this balance is easily misunderstood. The balance that copyright law strives for is not some ad hoc compromise or a shifting equilibrium of whatever might seem to maximize social welfare minute by minute. Copyright law should not be an instrument of raw social policy, and nor should fair use. The balance we are looking for in copyright law should come from the application of consistent principles that are derived from the fundamental structure of copyright itself. Is this possible? I believe it is. In a series of articles on the relationship between copyright and copy-reliant technology, I have argued that non-expressive uses of copyrighted works should generally be considered non-infringing. My theory follows the classic format of common law reasoning. It derives a principle from observations about the fundamental structure and purpose of copyright law, and then shows how that principle provides a coherent explanation for the relevant body of case law. Others are free to disagree, but if their approach to fair use, I think I've lost one now, if their approach to fair use is simply to replace a theory with no theory, I remain unconvinced. The architecture of copyright law is built around the protection of original expression, not the prohibition of copying. Original expression is what makes a work copyrightable in the first place. The contribution of original expression and control over the form of that expression is what distinguishes co-authors from mere assistants. Moreover, the exclusive rights of the copyright owner are defined by and limited to the communication of original expression to the public. We see this in the rights of public performance and public display, but we also see this in the idea expression distinction. Copyright draws a distinction between protectable expression that originates from the author and unprotectable facts, ideas, theories, systems, methods of operation, whether they spring from the author's mind or not. Copyright does not forbid the ordinary reader from extracting and reproducing facts and ideas or artistic techniques embodied in a work. In fact, it encourages the reader to do so. Moving beyond the idea expression distinction, the focus on the communication of original expression to the public is also evident in many other aspects of copyright law. Consider the threshold of substantial similarity. Similarity is determined from the perspective of the ordinary observer, and thus is inherently a question of how the work is communicated and received. Or consider the scope of the publisher's collective right. As the court ruled in Ticini, what matters is how the works are presented to the audience, not the data structure in which they are stored. Or consider the fact that courts generally refuse to base a finding of copyright infringement on undistributed and unpublished drafts. In my view, these are not isolated examples. They illustrate a more general principle. The copyright owner's exclusive rights are defined by and limited to the communication of original expression to the public. This understanding of copyright law gives us a framework to think about fair use, and it supplies the limiting principle that was missing in Laval's original formulation of transformative use and the Supreme Court's adoption thereof. Given the centrality of communication of original expression to the public, the critical function of fair use is to permit uses that, while they technically amount to acts of copying, do not in substance threaten the author's interest in controlling the communication of their original expression to the public. So Judge Laval was right to focus on transformative use, but the transformative use test would have been a lot less confusing if it had been explicitly tied to the benchmark of expressive substitution. Classic fair uses such as parody, commentary, and criticism are not merely fair because they change the underlying work or convey some new meaning or message. Most movies based on literary works add layers of new meaning and expression, but this does not make them fair use. The movie Rear Window exposed the original expression in It Had to Be Murder to new audiences and added a lot else besides, but it still required a license. In contrast, Two Live Crew's consistent parody of Pretty Woman qualified as fair use because the transformations they made were such that the parody posed no risk of expressive substitution to the original. The Supreme Court's decision in Andy Warhol Foundation versus Goldsmith emphasizes that transformative use is a matter of degree. The Andy Warhol case reaffirms the importance of transformative use, but it also implicitly rejects lower court rulings that had found uses to be transformative where there was no significant difference in purpose, merely the addition of a new vibe or new aesthetic. AWF helpfully clarifies the reason why transformative use has featured so prominently in the case law. The more transformative a use is, the less likely it is to substitute for the copyright owner's original expression. Using the author's work to reflect back on that work is intrinsically a different purpose. That difference in purpose makes expressive substitution unlikely. In contrast, merely adding an overlay of new expression while leaving the original expression intact provides no such comfort. The majority in AWF rightly focuses our attention on how the defendant's use is likely to substitute for the author's original expression and makes that the measure of whether the use is sufficiently transformative. This brings us to what I call the non-expressive use cases. US courts have consistently held that technical acts of copying that don't communicate the author's original expression to a new audience are fair use. I coined the term non-expressive uses to describe this phenomenon in a 2009 Law Review article in the Northwestern University Law Review. Examples of non-expressive use include copying software in order to extract uncopyrightable facts and interoperability keys through reverse engineering. An automated process of copying student term papers to compare their papers to other papers so as to detect plagiarism. Copying HTML web pages to make a search engine index. Copying printed library books to allow researchers to conduct statistical analysis of the contents of whole collections of books, and copying those same library books to create a search engine index. The case law indicates that even though these non-expressive uses involved significant amounts of copying, they did not interfere with the interest in original expression that copyright was designed to protect. Each use involved copying as an intermediate step towards producing something that either did not contain the original expression of the underlying work or contained a trivial amount. Non-expressive uses have consistently been held to be fair use in the United States. The relevant courts have explained their rulings in terms of transformative use, but it would have been better to recognize transformative use and non-expressive use as two distinct concepts emanating from a deeper principle relating to expressive substitution. Non-expressive uses, by definition, pose no threat of direct substitution. My point up until now has been that there are general principles internal to copyright that courts can look to understand the function and application of fair use. And that one such principle is that copyright was never intended to convey sole and despotic dominion over every use of every word. Copyright exists, by and large, to prevent the author's own original expression being communicated to new audiences without authorization or compensation. That realization suggests a positive vision for fair use. The critical function of fair use is to permit uses that, while they may amount to copying in some technical sense, don't in substance threaten the author's interest in controlling the communication of their original expression to the public. And that leads to the conclusion that non-expressive uses generally meet this threshold, really by definition. Now let's consider how this applies to generative AI. There are many different forms of generative AI, but it's useful to begin our analysis with an archetypal example, focusing on LLMs like GPT and text-to-image models like Stable Diffusion and Midjourney. To understand how copyright law and fair use should apply to the copying necessary to train these models, we need to appreciate 5 things. 1, models like these are not designed to copy original expression. Gathering and pre-processing the training data involves a lot of copying, but the training process through which the model learns from the data is not copying in any legally cognizable sense. Consider GPT-4. This is a large, really incomprehensibly large statistical model trained by exposure to vast amounts of text scraped from the internet. At the beginning of training, the weights attached to each one of the billions of parameters in the model are assigned randomly. So the first time the model encounters a phrase like the girl with the dark blank, it's just as likely to fill in that word with watermelon, galaxy, harmonica, propeller, or random punctuation mark. However, over the course of training, the system updates the weights in the model, reinforcing the weights that improve the guess and downgrading the ones that don't. Those weights don't reflect any single source. They're not the result of any single round of training. So a human who guessed that the word that might complete this phrase was hair, as some of you probably did, might have read that phrase in a book. It appears in many, or a poem, or on the side of a bus. But if hair seemed like a plausible guess to you, it's not really because of any one exposure. It makes sense because of repeated exposures, and also due to an implicit knowledge of grammar and of the things that people in our society associate with and choose to observe about girls. So when a language model learns to associate a higher probability with hair and a lower probability with propeller in this context, it's not copying any given text. It's learning from all of them, from the sum total. To be clear, the model isn't a human being. It isn't learning exactly the same way a human might. It doesn't understand grammar or society. Instead, it updates probabilities to reflect a statistical pattern which may itself reflect grammar and society. Although the metaphor of these models learning is imperfect, it still makes more sense to think of them learning from the training data than it does to think of them copying the training data, like a scribe in a monastery. The second thing you need to understand is that generative AI models typically learn from the training data at a very abstract and usually uncopyrightable level. For example, when a text-to-image model like Stable Diffusion or Midjourney is trained on hundreds of images that include the label coffee cup, it develops a model of what a coffee cup should look like. If the system is working properly, the model looks nothing like any individual coffee cup from the training data. So let's compare a random set of coffee cups from the Stable Diffusion training data with an image that I created of a cup of coffee that is also a portal to another dimension. The coffee cup depicted on the right shares some features with the coffee cups on the left. It's round, it's made of white ceramic, it has a small single handle, the color of the liquid is essentially black, transitioning to brown, but the cup is not substantially similar to any particular image from the training data, or at least none that I could find. Stable Diffusion is not an archive of images of coffee cups. The model has learned something about the latent concept of a coffee cup, but that concept is distinct from cakes and sunsets and newspapers and men with facial hair and women with smooth skin and all of the other things that you can see in the training data on the left. The third thing you need to understand about generative AI is that at the point of inference, at the point of creation, the outputs of generative AI typically combine multiple uncopyrightable latent features, further stretching or attenuating the connection between the training data that goes in and the outputs that come out. Consider, for example, the image that Midjourney created in response to my prompt calling for a teddy bear in rich, opulent clothing with ultra-realistic textures and a hypnotic stare reading a newspaper. No doubt, the picture is influenced by thousands of images paired with each of the relevant keywords. All of the images of teddy bears in the training data inform a latent construct of a teddy bear nested within the model's latent space. Likewise, all of the images of someone staring hypnotically inform a latent construct of a hypnotic stare. But the product of this particular prompt is something entirely new. A text-to-image model like Midjourney doesn't simply combine or unpack these learned latent features. Instead, it generates a novel instance that may share some characteristics with the input prompt based on the latent space. The picture is not just new, it's surprising. One of the fun things about this picture is that although the bear's demeanor is consistent with a hypnotic stare, the bear is actually wearing sunglasses. We don't know whether it's looking at us or not. The fourth thing you need to understand is that sometimes what I've said isn't true. Although generative AI models are not usually designed to copy their training data, sometimes they do. The computer science literature suggests that memorization is more likely when models are trained on many duplicates of the same work, or images are associated with unique text descriptions, or the ratio of the size of the model to the training data is relatively large. My research indicates that text-to-image models are particularly prone to produce infringing works when the same text descriptions are paired with relatively simple images that vary only slightly. This makes Stable Diffusion especially likely to generate images that could infringe on copyrightable characters like Snoopy or Baby Yoda, because these images occur in the training data often, but with variations. And these models are essentially primed to learn the copyrightable character. I refer to this problem as the Snoopy problem. You all know what Snoopy looks like. And from the Midjourney images on the left and the Stable Diffusion images on the right, it's pretty clear that these models do too. The fifth observation that I think is important here is that generative AI can become a tool of infringement in the hands of a determined user. It's very difficult to control the output of an LLM or a text-to-image model by simple prompting, but a user with detailed knowledge of a copyrighted work might be able to remake it, or at least something vaguely like it. And this is easier for works that are protected at a more abstract level, such as copyrightable characters, or which customarily entail very broad derivative rights, such as a novel. So when I asked ChatGPT to summarize Saturday by Ian McEwan, a novel that I tried to read and gave up on, and then asked it to imagine and outline a sequel to this book called Sunday, where the main character and Baxter meet again, it outlined a simple plot continuing the story that could easily be fleshed out into, and this is ChatGPT's own description, a meditative exploration of the aftermath of trauma, the possibilities of redemption, and the enduring nature of human connection. If I use ChatGPT to expand each one of the chapter descriptions, I could create my very own Ian McEwan novel. So in the right hands, a generative AI model can be used as a tool of copyright infringement, but the same is also true of a typewriter. With those technical observations in mind, I think we can say something about the fair use status of generative AI. As you all know, the fair use doctrine has 4 factors in the American statute. I'm going to take them out of order. As I have argued elsewhere, the second fair use factor, the nature of the copyrighted work, is not really a factor at all. It's simply the context in which courts must assess whether the defendant's use was justified under factor 1, whether the extent of that use was proportional or congruent with that justification under factor 3, and what the likely effect of the defendant's use would be on the market for or value of the original work, factor 4. In any event, the second factor has not loomed large in other non-expressive use cases, and I wouldn't expect it to in the context of generative AI. If we assume that in its ordinary operation, a generative AI model does not copy or produce copies of the original expression in the training data, then it qualifies as a non-expressive use. This kind of non-expressive use surely has a purpose and character that is favored under the first factor. Deriving uncopyrightable abstractions and associations from the training data, and then using that knowledge to create new digital artifacts is not just transformative, it is highly transformative. The non-expressive use of copyrighted works by generative AI does not usurp the copyright owner's interest in communicating her original expression to the public, because that expression is not communicated. If a use is non-expressive, then the third factor, which considers the amount and substantiality of the portion used, will also favor a finding of fair use. The ultimate question under the third factor is whether the amount of copying was reasonable in relation to a purpose favored by fair use. Although non-expressive uses typically involve making complete literal copies, that copying has been found to be reasonable because it's an intermediate technical step in an analytical process that does not lead to the communication of the underlying original expression to a new audience. Accordingly, courts in non-expressive use cases have found the third factor to weigh in favor of the defendant. The fourth factor is where things get interesting. In previous work, I have stressed that if a use is non-expressive, the fourth factor, which considers the effect on the market or the value of the copyrighted work, should also favor a finding of fair use. Viewed from a narrow perspective of direct expressive substitution, this must be right. By definition, if a use is non-expressive, it poses no threat of expressive substitution and should generally be considered harmless. There may be a market effect in some broader economic sense, but the market and value referred to in the fourth factor are not simply any benefit that the copyright owner might choose to nominate. A critical book review that quotes from a novel does not have an adverse market effect if it persuades people not to buy the book. A report from a plagiarism detection service might depress the market for helping students cheat on their homework, but that is not a cognizable injury under copyright law. And more broadly, copyright owners have no protectable interest in preventing criticism, parody, or simply locking up uncopyrightable facts and ideas. Nor can they simply claim, in circular fashion, that the right to charge for non-expressive uses is a cognizable harm, and that to avoid that harm, they must be given the right to charge for non-expressive uses. But perhaps focusing on direct expressive substitution alone is too narrow. Although non-expressive uses should generally be non-infringing, there is still scope for considerations of fairness in fair use that go beyond direct expressive substitution. An inquiry into the defendant's conduct under the fourth factor should consider whether the challenged use undermines the economic incentives that copyright is designed to create, even in the absence of direct expressive substitution. Consider, for example, the issue of lawful access. Copyright owners do not have the right to charge for transformative uses or non-expressive uses, but they have the right to charge for access to their works. It's widely assumed that OpenAI, Meta, and Google all chose to bypass the market for ebooks to train their LLMs on sites of known infringement or so-called shadow libraries like Library Genesis and Sci-Hub. Arguably, when commercial users bypass the market for access without a compelling reason, they undermine the economic incentives that copyright is designed to create. But here context matters. It would be unwise to elevate lawful access to a per se rule, even for commercial defendants. If it turns out that no one was willing to sell OpenAI a digital copy without a contractual promise not to engage in non-expressive uses, faulting them for obtaining their copies elsewhere seems a little bit churlish. Moreover, prohibiting academic research on illegal text corpuses will not generally benefit copyright owners or further the interests that copyright is designed to promote. A plaintiff might also argue that it's unfair to systematically extract valuable uncopyrightable material from a website and then use that material as a substitute for the functionality of the website. This argument would be strongest where the systematic extraction was likely to significantly undermine the website's incentives for original content production. Community-driven question and answer forums like Stack Overflow are already feeling the effects of generative AI. Traffic on Stack Overflow has decreased recently as large numbers of software engineers now turn to ChatGPT, Codex, and GitHub Copilot for answers. Part of the reason why these answers are so helpful is because these models were all trained on Stack Overflow. In response, Stack Overflow and Reddit and Twitter and many other sites have revised their terms of use and are looking to charge for access to their user-generated content. Finally, the unfairness of systematic indirect expressive substitution would seem particularly pronounced if that extraction is done by breaching paywalls, violating terms of service, or disregarding bot exclusion headers. It seems quite plausible that a court might extend the fourth factor to consider whether, in scraping material from the internet, the defendant ignored robot.txt files indicating a desire to opt out of search engine indexing and similar activities. No doubt, other aspects of fairness can and will be framed in terms of injuries cognizable under the fourth factor. The examples I've offered so far are merely illustrations of how broader policy issues can be channeled into our system of common law adjudication. Some people see the fair use doctrine as a lottery, or simply a delegation of policymaking to a poorly informed and unaccountable federal judiciary. That's unfortunate. The fair use doctrine has served us well in navigating several content technology disputes in the past, and I think it can continue to do so in the future if the doctrine remains grounded in general principles of copyright law. As I have said already, but I think it bears repeating, copyright was never intended to convey sole and despotic dominion over every use of every word. Copyright exists, by and large, to prevent the author's own original expression being communicated to new audiences without authorization or compensation. This suggests a positive vision for fair use, allowing uses that don't threaten the author's interest, but prohibiting the ones that do. The non-expressive use of copyrighted works in training generative AI is, by and large, one such use. Thank you very much.
So the question is, when you have the Snoopy problem, so the image derived from a limited field of material, would the issue of a derivative work come up? Because it looks more like that than something the AI very independently made.
Yeah. I'm not sure I entirely understand the question, because obviously anything that is simultaneously a copy of Snoopy but is also recognizably different from existing versions of Snoopy is a derivative work. But what people don't always appreciate, the sort of black letter US copyright law, is that to infringe the derivative right, you need to somehow embody a substantial amount of the original expression of the original work. So to a large extent, the derivative right is kind of surplus to the reproduction right. It just reminds courts that we take the reproduction right very seriously and very broadly.
Accepting for the sake of argument your expressive use limitation, even if the input of the data is non-expressive, the question is, isn't the output expressive? So to what extent should the analysis not be just about inputs, but also about the output, both in general and in this specific instance?
Yeah, that is an excellent question. There are different ways of attacking the issue of generative AI. One way is to say the reverse engineering cases and antitrust and iParadigms and Google Books, those cases are just wrong, and all of this copying is forbidden. Another way is to try and distinguish those cases. And in those cases, you had expressive work going in and metadata coming out. People say, aha, but here it's expressive works coming out, therefore the use is expressive. And this conflates a sort of First Amendment notion of what expressive means with what I mean by non-expressive use. When I talk about a non-expressive use, I simply mean a use that does not convey the original expression from the training data. And let's think about antitrust. I mean, in antitrust, English professors who I know have used the metadata to conduct really thoughtful statistical analysis about the representation of gender in Victorian novels over time. Well, that was an expressive work, those articles. The idea that you could produce data, but you can't do anything with it, doesn't really make sense. And so, I think it's partly a it's an easy definitional mistake to make, but I think it's a mistake. I don't think that the fact that these things are expressive is itself a problem. However, the fact that they're expressive might have implications under the fourth factor that weren't present in HathiTrust and Google Books in those cases. But it's still absolutely a non-expressive use because it's not conveying the author's original expression outside of the machine process.
So I want to ask a question that's sort of motivated by the legacy of, and work of Peter in the codes of best practices. One of the great innovations of that work was to translate fair use policy and copyright policy from the adjudicative environment into a set of guidelines and prescriptions for parties and funders and gatekeepers in the planning environment. So I was wondering if you had thought about how to translate your analysis of fair use in the context of generative AI, transpose it into a set of recommendations or guidelines that you would give to a current company or a prospective company that's trying to design an ingestion system from the beginning.
I did not plant that question. So forthcoming in the Houston Law Review shortly is an article called Copyright Safety for Generative AI, which proposes a set of best practices that when I wrote them a millennia ago, i.e. 6 months ago, seemed like the sort of responding to the cutting edge of what was happening in the technology. I intended these best practices as the beginning of a conversation because, clearly this is an evolving situation. I think there is a lot that researchers and corporations using this technology can do to make it fairer, to decrease potential harms. And we're not just talking copyright harms. And, I think that they should do that, like just as a matter of ethics, whether or not it affects the fair use calculation or not. Now, the specifics of the recommendations kind of vary a lot with the context. And it's something I would like to see others, including the Copyright Office, continue. It's actually like having an informed dialogue about how to reconcile competing interests, how to minimize potential harms while we, to some extent, put some of the legal liability issues to one side. Because, what Stability AI did with stable diffusion, even if it was lawful, it was not necessarily careful. And, I think in retrospect, they could have done better for one.
The solution you offer is applying fair use to non-expressive forms of copying. But couldn't you also take the analysis one step upwards in the chain of analysis and look at what reproduction or what copying really must mean? And this, of course, is familiar territory. The discussions about the WIPO copyright treaty in the 1990s were about exactly that, all this intermediate technical copying that does not reproduce any expression as such, but is basically about what a machine does and is instrumental in all kinds of technical process, including search and many other things. In those days, there were many scholars already who said we should look more normatively at this concept of reproduction, and not everything that looks like a copy from a technical perspective is a copy from a legal perspective. So infuse some normative analysis at this higher level. You're doing it at the fair use level, but could you also go one step beyond and apply this theory that copyright should only protect expressive uses at the level of the economic rights?
Yeah. This is a very appealing argument, but it has problems. Firstly, just in the US context, it's a sort of statutory non-starter and it conflicts with our history. I mean, the Supreme Court in the White Smith case said, oh, music on piano rolls, no one can read it, it's not a copy. And then Congress came in and they rewrote the act to say, no, it's a copy. But, who cares? Like, we could rewrite the statute, we could change our thinking. Conceptually, I think the problem is that the line between expressive and non-expressive is often not going to be clear. It's often going to involve a factually contextual evaluation. And so if we're just throwing all the weight onto a binary classification, we still engage in the same analysis. We just move it further up the chain. And then in fair use, we're already doing a contextual evaluation. It makes sense to do it there. And then the third reason why it doesn't work is because we have this terrible thing called computer software. And Congress, in its wisdom, made computer software a literary work. And if I copy Microsoft Office in order to use the program and not to appreciate all the expression in the ones and zeros, that sounds a lot like a non-expressive use. But I wouldn't want to see, and nor would I think a court accept, my theory of non-expressive use being used to completely eviscerate copyright protection for software. So I can see conceptually why what you're arguing is attractive. I don't think ultimately it works, and it really doesn't work in an American context.
Great. Others? I see a lot of men raising their hands, and periodically I have to raise this in class. There we go. Thank you. I feel like an auctioneer, and I've got a bid.
Yeah, I have a question about the implications for authorship. So I imagine not in the near future, but eventually when a critical mass of new works are made, either primarily with or with the assistance of generative AI, that the idea of authorship needs to evolve as that generative AI begins to produce works that are themselves based on other generative AI produced works. So in that potential future, does the idea of authorship evolve or maybe even disappear completely?
I think that most new technologies of creation have changed the way we think about authorship. Certainly the camera has changed the way we think about authorship. The camera is this mechanical thing, but we recognize it as an authorial activity, and most photographs get copyright protection. I think that we will have to change the way we think about authorship to some extent, but I think that what the Supreme Court said in the Sarony case in, help me out, like 1874 or something, when it was trying to figure out who owned the copyright in a photo of Oscar Wilde, it said, authorship is ultimately a matter of who controls the final form of the expression, whose intentions are manifest in the object. And I think that will remain. But the Copyright Office at the moment is really struggling with how do we treat images created on Midjourney, for example. And they have to figure out an administrable system that doesn't reward people for merely suggesting an idea to Midjourney and then pulling a slot machine and accepting the result. The problem with that is, I think that selection amongst alternatives is a form of authorship. And if you think about what it means to take a photo, you frame the camera and you wait for the right moment. It is really just a process of selecting amongst potential alternatives. And I think conceptually, we are going to have to think differently about authorship. Administratively, I'm not really sure what the Copyright Office should do. But yes, I think this technology will change the way we think about authorship.
With that, I think it's obligatory to advertise, since we have members of the Copyright Office in the audience, that the Copyright Office has a current notice of inquiry out there and would love to hear from you. And apparently I've heard from 120,000 people already, but that doesn't mean your opinion doesn't count. Please let them know. Peter has a question.
You explained that under your analysis, there might be situations in which, under the fourth factor, something other than ordinary expressive substitution might nevertheless count. The examples you gave included the uses that somehow breach or avoid the copyright owner's market for access on the one hand, and then uses that might involve the breach of paywalls. My question is it possible that giving weight to those considerations is really just a way of bringing in sideways the good faith, bad faith test, which many of us at least think shouldn't really be a test at all in fair use?
I hope not. I think it's always important to look at what you've written in the past and think about the extent to which you might have been wrong, the extent to which you might have seen the world too simplistically. I think when I look back at my past writing, I think that the criticism that James Grumman makes that I will accept is that it seems pretty binary. It seems like, if it's a non-expressive use, then these robots can do whatever they want. And that seems problematic. And I think, you could easily read my work, almost to suggest that. And I don't think that's right. I think that if a use is non-expressive, that's really important. Like it's really important under the first factor, and it colors how you're going to interpret all the other factors, but it's not the end of the story. And the thing that I think makes the fair use doctrine work, and broadly has made the fair use doctrine quite successful, is that it provides a way of channeling some of these broader public policy issues into things that are legally cognizable, things we can talk about as lawyers, things for which we can have precedent and cases that build on other cases, et cetera. And so, my discussion of the fourth factor here, some of this is somewhat speculative. But I think, there is clearly, there is more to the fair use question than whether a use is technically non-expressive. But that's still a major thing. And if you recall Campbell versus Acuff Rose, the Supreme Court didn't even decide, oh, that's definitely fair use. They kicked the fourth factor back for reasons I've never fully understood, but to allow for the possibility that this parody could affect the actual market for non-parodic rap derivatives of Roy Orbison's stalker ballad, Pretty Woman. Which I think was just throwing a bone to Justice Kennedy. But, I think, so I don't think it's reintroducing good faith, bad faith, because the heart of the bad faith inquiry was, that you sought a license and were told you couldn't do it and you did it anyway. I think the question here is, are you fundamentally undermining the incentive systems that copyright was meant to create? And, I don't know how the courts will rule on the shadow library argument, but I think it is the strongest argument. I don't know whether I'm even personally convinced by it, but I think it is the strongest argument against, the current wave of generative AI that we have. The argument that this technology will cause unemployment in the relevant cultural sectors, as a policy matter, that's compelling. There's no doubt the graphic artists are going to be significantly affected by what's going on right now, but in a way that's quite uncalibrated to whether their works were used in the training data, right? And so that's just a very hard thing for copyright to process. And ultimately, I think copyright is just not the right forum for solving that problem.
Great. We got one more. I'm going to give it to Jacob, and then we'll do some closing remarks, and we'll take the rest of the conversation outside. Before you go, there's one factual question online that I think we can clear up pretty quickly, which is the copies made during training, are they kept for long enough to count as non-transitory? And I think the answer is clearly yes.
Oh,
right?
yeah. They're kept for months and months, possibly forever. And I think it's really important to understand, I mean, forever maybe is exaggeration, to understand why. We want OpenAI to remove all of the documents that praise Adolf Hitler from the training data. We really want that. We want OpenAI to try and deduplicate the training data. We want OpenAI to think about, race, gender, sexuality, etc., distribution in the training data. All of that stuff's really difficult to do without a fixed copy of the data to analyze. And so, a transient copy might be for, a second or two. These copies, they're sitting on hard drives to be used for the next round of training. There's definitely a ton of copying going on.
Great. All right, Jacob, go ahead.
So I like your framing of the fourth factor being used to sort of police the effect on copyright incentives independent from the sort of transformativeness of the use, whether non-expressive or expressive. My question is, do you think Warhol, I know it sounds like you're more of a fan of Warhol v. Goldsmith than maybe I am. Does the insertion of this kind of commerciality aspect into the first factor transformativeness analysis muddy that waters? Are we now going to basically be having cases where we're looking at like Google Books and iParadigms and all these transformative use cases, non-expressive transformative use cases, and we're looking at commerciality and effects on copyright incentives in the transformative use analysis because of what I think mess that Warhol v. Goldsmith made of the first factor?
So the majority opinion in Warhol came as absolutely no surprise to me, and I think is broadly correct. What Justice Sotomayor says about commerciality is just that it's something else that is important. But then she repeats everything that Campbell said about commerciality. Like the presumptive rules about commercial use from Sony and Harper are dead. And they're still dead after Warhol. What's difficult for the courts is to figure out whether commerciality is like a separate thing under factor one, which it almost certainly isn't, or rather just, kind of important under factor four, which it almost certainly is. And I think, when we have not-for-profit researchers engaging in non-expressive uses, the fact that they're bypassing a non-existent market that they have no funds to pay for doesn't seem too problematic. But when we have, wealthy companies like OpenAI and Google and Meta, who could have bought a bunch of ebooks but chose not to, that seems like an issue that might grab a court's attention. And what I'm suggesting is, if it's grabbing your attention, Your Honor, it's under factor four, right? And that is where you need to think about it and process it.
Great. All right, Teresa.
I'm coming from Europe, and as you know, we have a specific exception that is now being discussed, whether it allows the type of uses that you have analyzed here. And of course, when you describe your considerations of fairness that go beyond what you would normally consider, and you mentioned lawful access and failure or not to respect the opt-outs, I look at that as the type of considerations that you lawmaker has made and has included in our specific exception. So I was wondering whether you were inspired by the TDM exception in Europe, because there is a lot of similarities. And even here in this room, I've heard a lot of people here complaining about the EU TDM exception for commercial uses because of the opt-out. So one of the reasons why people dislike it is because of the opt-out. But I now see that perhaps under your theory, a proper application of fair use in this case would require respecting that opt-out. So I'm just kind of trying to be inspired to kind of continue to defend the opt-out in Europe because it has been hard to defend that.
Yeah, so I think the distinction in the EU under Article 3 versus 4 of the Digital Single Market Directive between essentially commercial and non-commercial users is a little too rigid, right? But is broadly correct, right? The problem with, as I see it, the problem with the European approach is that, just tries to encode things in sort of harder rules where, perhaps a little bit more discretion and judgment and context would be appropriate. And so in the EU, even for non-commercial users, lawful access is required. But does that mean that academics can't study Sci-Hub in order to write articles about the contents of Sci-Hub? If you don't know Sci-Hub, by the way, it's a cache of basically every academic article ever written, run out of some Russian website, maybe, I'm not sure, but
It moves around.
It moves around for obvious reasons. And so that's problematic, but I think there is something to the commercial, non-commercial distinction, because ultimately, perhaps the large corporations should be paying for access to their inputs. Particularly, if you trained an LLM or fine-tuned it on the contents of today's Wall Street Journal and released that as a product where people could talk to the chatbot as they drove into work and not have to buy Rupert Murdoch's newspaper, that seems, it would be great. I would love that. But that seems like that would be, really undermining the incentives that copyright is meant to create. And so we see companies beginning to pay for access in private markets. And I think opt-outs will drive actual market solutions that are much more plausible than any sort of compulsory license discussion that we might be having. And so, I must admit, when I saw Article 3 and 4, initially I was like, oh, they shouldn't be making this distinction between commercial and non-commercial. But I've come around. I actually think that it broadly makes sense.
Great. Okay, so we're about to close. I just have a couple of things for the students in the room, in particular. This is a moment. November 22 is when ChatGPT 3.5 got released, and suddenly people were like, oh my God, what is this? Now, it had been bubbling along. There's nothing new per se, but what's happened is the scale of these models has increased to the point where the outputs are now demonstrably more powerful than they were. So it's a moment for students to grab. I want to say the folks who are sending us all emails as professors saying, I want to write a note on AI and I would ask you to law first, facts second. What's the legal question that you want to apply to AI? Don't start with the facts and then hope there's a legal question to be found. So if you want to write about AI generated music, which copyrighted rights in music are you interested in exploring? This is not a business school, so we're not doing business cases on how to make money on AI generated. Okay, so that's point one as a law student. As a future lawyer, this is the time to get to know how these technologies work. If you understand the technical facts, you can be much more useful to your clients, whether it's in IP and copyright or other areas. And these technical facts are going to keep moving. This is the hard thing about being in the space, is you've got to sign up for tuition and you're going to keep paying because you got to keep up and you got to keep learning. But this is a moment. And the reason we know it's a moment is because generative AI is a general purpose technology. The personal computer is a general purpose technology. Boom. The internet is a general purpose technology. Boom. Generative AI, unlike cryptocurrency, is a general purpose technology. Tick, tick, boom. Let's take a break.